Hello, everyone. Thank you so much for attending our webinar today on the International Entrepreneur Parole Program. My name is Sonia Sidhu, and I am an Executive Manager with Chugh LLP in our Cerritos, California office. The International Entrepreneur Parole Program, or IEP, provides an opportunity for foreign national entrepreneurs to enter and remain in the United States to work on their businesses. Today, our expert panel will share insight into what it takes to qualify for the program, what parole entails, and some practical legal basics for operating a business in the United States. If at any time you have questions during the presentation today, please enter them into the Q&A chat box. Today, I'm joined by a wonderful panel of speakers, including Grisham Chatter, attorney, Shweta Gopalkrishnan, attorney, associate attorney, legal consultant, Kirti Kaura, partner, attorney, Rajeshri Rajashakaran, attorney, legal consultant. So with that, we'll get started. Now, this program is really exciting. Kirti, could you provide an overview of what the IEP entails?
Hi, Sonia. Welcome, everybody. Yes, I would be happy to provide an overview. Well, the International Entrepreneur Parole Program allows founders of startup companies to come to the U.S. and work lawfully in the U.S. for a period so that they can get their company funded and started, and ideally to benefit the U.S. economy. The program allows entrepreneurs to live in the U.S. and work on their business for up to 5 years if they meet certain conditions. It is important to note, though, that the program does not offer a direct path to a green card or citizenship. The purpose of this program is simply to unleash the entrepreneurial energy to benefit the U.S. innovation and job creation. The program is available. Program was made available effective May 2021. It was an initiative of the Obama administration, and near the close of 2016, they had it was made available to use, but within a few months, it was put on hiatus, and the Trump administration tried to get rid of it entirely in 2017. The rule was resurrected again under the Biden administration in early May. We believe that DHS actually expects about 3,000 applications this year for this program, and they're hoping that the rule creates approximately 500,000 jobs focusing on STEM employment.
So the IEP provides parole to foreign nationals, which is not the same as a visa. Kirti, could you explain what parole really means?
Right. There's a clear distinction between parole and visa. We have to keep that in mind. This is not a startup visa, but it accomplishes the same goal. Only the Congress can create legislation to create a visa program. This was created by the Obama administration, so they were limited to this option by creating a parole program. So this parole program, it provides applicants with a period of authorized stay for about 2.5 years initially, with an additional period of 2.5 years if they meet certain criteria for 5 years, or a total of 5 years.
So we'll get into
allows you to travel in and out of the U.S. A visa document allows you to travel in and out of the U.S. And it's usually offered by consulates abroad in the country of origin. Parole is permission to enter the U.S. Were you saying something, Sonia?
No, not at all. No, please continue.
Oh, sorry. Parole is a permission to enter the U.S. to act in a particular way. In this case, work for your startup company, develop it, create jobs, and benefit the U.S. economy. You're authorized to work on only one approved startup company. You can't have multiple going at the same time. The US government can also revoke this parole if the startup stops operating or providing public benefit to the US. Parole status does have some drawbacks. A successful IEP parolee may not file an application inside the US to change status to a different status, such as an H-1B or an L. The entrepreneur will have to leave the company and apply for a new status to re-enter with a visa. With the parolee, it's also not possible to change to a different status. For example, you get the company going started, and then at some point you switch to an F, an O, or an H. That's not allowed with the parolee because it's not a visa status. It's just an authorization to be in the U.S. for particular steps. So instead, for this, if the startup entrepreneur is in the U.S. at the time when they decide to start the company off, in order to get on this IEP parole, they have to first leave the country after the 941 is approved and come back in on a parolee permission. However, the distinct advantage is that this works very well with the startup environment and is not restricted by the restrictions on other work visas that have wage requirements and location and other more restrictive items. The dependents can qualify, such as a spouse or children, to join the parolee. Spouses can work anywhere legally. The beneficiary must work at the startup only, but the spouses can work anywhere. Children, again, are not authorized to work. Why is this rule in place? Well, many visa programs are not available to everyone else. This was an option for those individuals. For example, an E2 investor is not open to many countries like China, India, and Brazil. Under IEP, any national can apply from any country. Also, many visa programs only allow one person per company to be sponsored on a visa type. For example, an E2 treaty visa allows for only one founder. The IEP program allows for up to 3 founders. Also, there are other restrictions such as, for example, in comparison with EB5, the visa requires a significant amount of investment. There's no investment required from the individual for IEP program. The International Entrepreneur Program does not offer, a direct path to permanent residence or green card. Individuals who would like to apply for a green card will need to qualify under different immigration programs, such as other employment-based green card categories.
So we'll get into the details soon on how to qualify for the IEP. But first, Curti, could you provide an overview of the requirements for the program?
Right. The summary of the requirements are 3 basic requirements. You must have a new startup entity in the U.S. for which you are the founder. Second, the applicant is an entrepreneur of the startup entity who will work only for that startup. And the third, the startup entity must have received significant U.S. capital investment or government funding. And that funding can be from investments from U.S. investors, government grants, and alternate criteria are acceptable, but they would have to prove eligibility, and it's going to be under the discretion of the USCIS officer. USCIS officer will consider the totality of the circumstances to determine the eligibility for IEP. Whether or not the startup will provide significant public benefit will also be considered.
Thanks, Curti. Now let's dive into the details. Rajeshri, what is required of the startup business for IEP?
I'm happy to answer that query, Sonia, and thanks to Kirti for succinctly putting forth the summary of requirements. So circling back to what Kirti said first, of course, the formation of a startup entity becomes of paramount importance as far as qualification under the IEP is concerned. There are a couple of factors that the USCIS looks into herein. First being the age of the startup entity. So the startup entity should have been formed in the preceding 5 years from the date of application for the IEP program or the date of grant of the investment or the award. Thus, in a nutshell, the startup should have existed for a period of 5 years or less. Now, moving on to the second factor, of course, the startup should be engaged in a legitimate legal business. Now, this could be research, development, participation in accelerator programs, or a business where it's constantly receiving queries about what it does. Or it could also be that certain legitimacy is reflected in terms of the startup engaging in negotiation for agreements. What this factor essentially tries to gauge is that the startup is not a passive entity. The next factor that the USCIS looks into is the potential for rapid growth as well as job creation. So as far as this vertical is concerned, the USCIS would look into business plans, their projections. Essentially, they're trying to gauge if the startup has actually gotten off the ground and is still not in its nascent stages of development. Now, this is a very fragile balancing act that the USCIS does with the startup's potential for rapid growth on one side and job creation, and on the other, the reasonable time of 5 years in order to expand its legitimacy, its business, as well as government funding.
Thank you. There are some important criteria that the applicant must meet as well. Could you give us an overview of those requirements, Rajeshri?
Sure. The applicant herein, in order to qualify for the IIP program, must be an entrepreneur. Now, what exactly qualifies as an entrepreneur is that such an individual should have a significant stake in the ownership interest of the startup. What the USCIS considers significant is 10% or more. And along with this significant interest of ownership, the individual should also be in such a place so as to play a central role in the operations of the startup, as well as be well positioned in order to charter the journey of startup. So once again, the USCIS is trying to decide if this person is only a passive investor or if he is actually actively involved in the operations of the startup. Now, there are a couple of factors herein. One thing that the USCIS would look into is the knowledge, the skill set, and the intelligence that this individual possesses in order to qualify as an entrepreneur. The second would be the track record of such an individual in making investments and in handling startups of this sort. And of course, there will always be a case-by-case analysis of the kind of central role and well-positioned designation that such an individual has in order to qualify himself or herself as an entrepreneur.
Thank you so much. The entrepreneur's business must also meet investment and funding requirements. Rajeshri, what are those guidelines?
Absolutely. So there should be a significant US capital investment or government funding. Now, what the USCIS intends to look into as far as capital investment is concerned is that there should be an inflow of investment from qualified US investors or from established US investors with a track record of such investment. Now, the minimum mandated cap for the US funded capital investment is $250,000. The alternative herein is government funding, which of course can be by way of grants from the state, local, or federal governments. And the minimum mandated cap herein is $100,000. Now, what's interesting is under this particular vertical, there is something called alternative criteria, which is a catch-all factor. In case a startup is not able to meet the minimum mandated caps under an investment funding or be it government funding, they can always appeal to the discretion of the USCIS and let them know that they are on the way to these minimum mandated caps, and they could request the USCIS to look at their scenario under the totality of circumstances. Say, for example, a startup was getting 50,000 from venture capital and 30,000 from government grants. The startup does not qualify under the IEP because they've not met the minimum mandated caps. But once again, at the risk of repetition, you could always appeal to the USCIS under the totality of circumstances and submit that there is reciprocity herein because ultimately it leads to public benefit here in the US.
Thank you. And what type of capital is required for these investments, Rajeshri?
Right. So the USCIS tends to look rather closely at the kind of capital infusion that happens in the startup as far as an IEP is concerned. Now, capital could be equity. It could also be convertible debt or any such other financial instrument that usually finds mention in the startup scenario. Now, what's interesting is even non-monetary contributions can qualify as capital under the IEP program. So examples of non-monetary contributions could be licensing deals, patents, etc. Now, I know a lot of people might have a question about this, right? So what happens if the investor or the entrepreneur himself invests money? So here's the catch. The entrepreneur or anybody that's or is related to the entrepreneur, say a sibling, a parent, a child, or even a spouse, or any other entity in which any of these people are indirectly or directly associated with. Now, they can invest capital into the startup. Unfortunately, such an infusement of capital will not qualify for the IEP program.
Thank you so much. Investments in your business must come from a qualified source. Prashant, who is a qualified investor?
Yes, thank you, Sonia. So qualified investor can be an individual or an organization. They must be U.S. citizen, a lawful permanent resident, or entities that are majoritarily controlled by a U.S. citizen or a lawful permanent resident. You may take foreign investments. It just does not count for eligibility for the EIP. The qualified individual or organization must have made a total of at least $600,000 total investment in a startup entity during the preceding 5 years, and they have invested in more than just your company that you're starting. There also needs to be a track record of successfully investing in 2 startup entities that, after receiving their investment, each created at least 5 qualified jobs or generated at least $500,000 in revenue, with average annualized revenue growth of at least 20%. What's forbidden is foreign investors. No bootstrapping or self-funding qualifies. On a side note, investments made through an SEC-compliant crowdfunding platforms may qualify.
Thank you. And beneficiaries of IEP can extend their parole and remain in the US for longer. How does someone qualify to extend their parole, Goshen?
Yes, re-parole is allowed for an additional period of 30 months or 2.5 years. In order to do so, you must meet the following criteria. A continuation of the startup entity activities. The business should still be in operation. The entrepreneur continues to be a central and active part of the organization and has at least 5% ownership. You can give up ownership in order to fund your company, which is why ownership percentage is allowed to be reduced here. The organization continues to have significant U.S. investment, revenue, job creation by evidence of additional qualified investments or grants, at least $500,000, revenue growth of a minimum of $500,000, and annual revenue with average annualized growth of 20%. Job creation of a minimum 5 full-time jobs of qualified U.S. workers, and there are alternative criteria, the catch-all criteria, which allow us to show that your company has significant potential to grow and create jobs, even if you do not meet the listed criteria.
Okay, thank you. And what opportunities does an entrepreneur have to remain in the U.S. after they have maxed out their parole, Goshen?
Yes, so after you have extended and maxed out your stay, you must depart unless the entrepreneur can stay under other lawful status. At any time, applicant can start an immigrant or non-immigrant petition. These include an O1 visa, an EB1, an EB2, and any other employment-based petitions. However, no adjustment or change of status is allowed within the U.S.
Interesting. What is the application process like for IEP, Goshen?
Yes, you would need to file a form I-941 with the USCIS. The filing fee is $1,200 plus $85 for biometrics fingerprints. The dependents will file a form I-131 application. The spouse will file a form I-765 for employment authorizations. Once approved, applicants will present the documents to CBP with approval letter. Applicants can file while inside the U.S., but once approved, the individual must depart and apply for parole entry at a U.S. point of entry. USCIS will consider applicants with past immigrant transgressions, including unlawful status or overstays, and depends on their discretion.
Okay, thank you so much, Krishan. Now we are going to shift gears and focus on some important legal considerations that foreign national entrepreneurs should be aware of in the United States. Shweta, could you tell us about entity information? Sorry, Parole.
Absolutely. Thank you, Sonia, and thanks to everybody for joining in today. So as we know, starting a US-based company as a foreigner can involve a number of decisions. One of them is choosing the type of entity that you want to incorporate. The second is choosing the state where you want to incorporate. We'll get into the second aspect a little later in the presentation. With respect to entity choices, there are a number of entity forms that one can choose from. There are the corporations, there's the limited liability company, there's partnerships, and there's sole proprietorships. A corporation is essentially a single entity which is comprised of individuals in the company, but it has its own separate in legal form. Among the most important features of a corporation is limited liability, which means that the shareholders may take part in the profits through dividends or their stock appreciation, but they're not personally liable for any debts that the corporation has. And corporations always are not for-profit corporations. There can be benefit corporations. They can also be non-profit corporations. C Corps are one of the most prevalent forms of corporations that individuals do choose to incorporate, which involves double taxation, which means that the corporate form is taxed on its profits, and then the shareholders are taxed on the profits on their personal income taxes as well. One of the most up-and-coming types of corporations are again the S Corps, which are subchapter S corporations, wherein they're pretty much like C corporations, but the only qualifications are you have pass-through taxation in an S Corp, which means that the owners are taxed on their personal income taxes once they get the exemption from the Internal Revenue Services through the IRC. And the other is the class of stock as well as the number of shareholders differs for the NS subcorp S corporation, which means that it is for an S Corp, you can have only up to 100 shareholders, which can be individuals or certain qualified estates and companies. And all these individuals must be must be US nationals, and foreign nationals are not allowed to be shareholders of an S Corp. Luckily enough, we have the LLC, which is a hybrid format between a corporation as well as a partnership. An LLC allows a corporation, the corporate form, and allows individuals to have the pass-through taxation of a partnership, which means that the owners are taxed on their personal income. However, it gives the limited liability aspect that corporations are so well known for, wherein the owners are protected from liability on the debts. And any entity form can form into a LLC, and that's a choice that business owners can take.
Thank you. What are some things that entrepreneurs should consider when choosing the state for incorporation, Shweta?
Absolutely. That's definitely a good segue into our next section, which is when it comes to corporate law in the US, it is not governed by federal law. It depends on each individual state where a person decides to incorporate. And there are two factors which determine this. One is the business that a company chooses to partake in. If one state dominates the market, for example, if it's a tech-based company, then you would obviously go for the states where your services, your products will be most prevalently sold or most prevalently given out. However, if you do not have one state that dominates the business, then Delaware is usually the choice that most individuals go for because of a variety of reasons, which includes the fact that corporate law is very flexible in Delaware. Very minimal compliance is required when it comes to mandated compliance for companies, as well as the corporate laws in Delaware are very investor friendly, not just for investors and founders, but also for incoming shareholders, venture capitalists. Second is the amount of money or the source of money that the corporation would choose to raise from. Usually venture capitalists and investors prefer Delaware because of the friendly laws that Delaware has. And in that case, C Corporation in Delaware is an obvious choice because of the limited liability aspect, as well as you get investor-friendly laws. If, however, foreigners or if, however, entrepreneurs do not know where the money is coming from for investment, which is absolutely fine, as US does not require a minimum capital requirement for starting a business, then one of the ways to do this is forming a limited liability company and then converting it out to a C Corp once you do have an idea of the investments and the funding that the company will have in the future.
Okay, thank you. So corporations must meet certain requirements in how they are operated. What are some of those, Shweta?
Absolutely, Sonia. Once a corporate form is incorporated, the first step is, of course, articles of incorporation with the state of an individual's choosing or depending on where their business is based. Once the articles are formed, then is giving out the stock to the owners of the corporation, thereby being stockholders and shareholders of the corporations. In the annual meeting, which is mandated in almost all state laws in the US, the shareholders usually elect board of directors, whose duty is basically to take over the operations of the company, to maintain the corporate purpose. And these board of directors, more often than not, do end up appointing certain officers, such as the chief executive officer, the chief financial officer, to take care of certain aspects of the business. Although the members of the board are not generally responsible for the debts of the company, they do owe duties of loyalty and of care to the shareholders as well as to the company. Duty of loyalty essentially means that, board of director or an officer should take care of the company's business with respect to, without any conflict as to their own personal affairs, as well as without stealing any corporate opportunities from the corporation, which is meant for the corporation and not giving it to anybody else. And then duty of care is essentially using reasonable process and reasonable judgment, also known as the business judgment rule in under corporate law, to further the business's goal. And although the board is the group of people who are responsible for making strategic and policy decisions for the company, it's not that the shareholders do not have any rights. The shareholders have the right to choose the board, and if they do not agree with the board's decisions, they do have the right to change the board members. They have the right to vote on certain important decisions such as dissolution, dividends, and mergers and acquisitions of the company as well.
Thank you so much. So what are the common types of equity investment structures for startups, Shweta?
When it comes to startups, there are a number of investment opportunities and types of investments. The four most prevalent ones are common stock, preferred stock, convertible note, and safes. Common stock essentially are the most basic type of stock that is given out in a corporate form, which includes your right to vote, which includes your right to own a stake in the company. Preferred stock goes a little step further. It is essentially your right to own a stake in the company while giving you certain preferred rights, usually in the form of liquidation. For example, if a company liquidates, then the preferred shareholders get their dividends and get their amount first before the other common stock holders. And the other is also voting preferences and voting rights as well. Convertible notes are another form of investment, which are quite prevalent in startups, which essentially is a form of equity investment in a company. They are a loan to the company, and they do not essentially come with a preferred stock at the time of investment. However, the loan accrues over time, has a maturity date, and once it hits the maturity date or it hits a triggering event, for example, running into an IPO or getting into a new round of funding, then this convertible note converts automatically into a preferred stock for the shareholder, thereby giving them the right and a stake in the company. Then come the SAFEs, which the acronym stands for Simple Agreement for Future Equity. As the name suggests, they do not represent a current equity stake in the company. They are merely an agreement that a person has with the company for future stake in the company. Once a triggering event is met, a SAFE converts itself into a preferred stock as well, just like the convertible notes. However, it does not accrue any interest and does not have a maturity date, unlike the convertible notes, because they're not loaned to the company. They're just a agreement to have a future equity in the company.
Thank you, Sweta. Now, what should entrepreneurs be aware of when it comes to intellectual property laws in the United States?
Absolutely. While entering the U.S. Business force, one of among the decisions that people have to take for incorporating their corporate form, and another important decision is carefully protecting their technology and creativity in the U.S. market. The basic type or the basic forms of protection that US offers all entrepreneurs is through copyrights, patents, trademarks, and trade secrets. Copyright is essentially your protection for works of authorship, which can include a computer code, an architectural design, or even a book. And although filing with the US Copyright Office is not mandated, it is a preferred form and also an evidence of protection and an evidence of your ownership if you do choose to go register with the US Copyright Office. The United States copyright laws are a little flexible in their requirements, which is why they are growing out to be one of the most preferred forms of protection when it comes to software codes, as opposed to patent laws or even trade secrets, if they do not meet the stringent requirements of having the novelty of a patent or the know-how or the technicality of a trade secret. Then comes the US patent law, which is protection that can be used for any machine, an article of manufacture, composition, as long as it is novel, it's non-obvious, and it is eligible for being protected as a patent. A patent must be filed within 1 year of commercial use, disclosure, or offer for sale. This is different than most countries and most countries require absolute novelty, while US does not have that stringent requirement. Then comes trademarks, which help protect logos, service marks, your trade names, as well as any other forms of goodwill for the company. In the US, trademark applications can even be filed before the trademark is used, thereby preemptively protecting your right to use the mark before anybody else does. And lastly, we have trade secrets, which essentially protect your valuable secrets and know-how. One of the most famous examples is a formula for Coca-Cola. Until recently, trade secrets were governed by state laws in the United States. And since June of 2019, there has been a shift in gears, and there is a Uniform Trade Secrets Act, which is a federal law that protects trade secrets. This is not in all states of the United States except New York and North Carolina. And these are some of the types of protection that entrepreneurs can, take benefit of when they do choose to come to the US and protect their intellectual property as well as their technological know-how.
Thank you so much. So that brings us to the end of our presentation for today, but we still have time for Q&A. If you haven't already, please enter your questions into the chat box. Is there any questions? So a few of the questions I'm not too sure. What are the pros and cons of an S corporation? S corporation? Does anybody want to take that?
Sure, I'd be happy to take that, Sonia. As we briefly discussed, one of the pros of an S corporation is pass-through taxation, which means that it can avoid the double taxation that C corps have, because once you qualify as a subchapter S corporation, only the owners are only the owners are taxed on the profits as opposed to the corporation being taxed on the profits and then the owners. So that's one of the benefits of being an S Corp. And was there a second part to the question?
I didn't see a second part. I also see apologies. No, I didn't see a second part of the question. So any other questions? I think what we'll do is we'll get back to the Q&A, the questions, and each one of you can respond accordingly. So we'll go ahead and end it, and then we'll respond to each question that's been raised. So what is the minimum that foreign investor needs to bring to California? Yes, there is some questions. What is the minimum that foreign investors to bring to California? Is this where they want to invest? Can someone take it? Shweta?
Absolutely. I think when it comes to capital requirement, there is no minimum capital required per US corporate law. So you can technically start a company without having, there is no minimum requirement in California as such for starting a corporation. You can start a corporation, you can incorporate it, and then once you do have an understanding of the services or even the US market, you can go through series of fundings and through angel investors or seeds, and you can raise financing for the company. I hope that answers the question.
Yes. And is there any other questions with that, please? If there's no other questions, we'll go ahead. Could it be to start a new, I think the question is, let's see. Could it be to start a new venture, to expand a new venture, for example, a hotel or restaurant, or start a chain of hotels and restaurants?
Hi, Sonia. I'll be happy to take that question. So long story short, it can't be an expansion of an already existing venture. So like I said, it has to be a startup. But if the question is regarding the age of the entity per se, then it should have existed at least 5 years preceding the date of the application for IEP or the date of the investment or award. So that's exactly what we need to look at as far as duration requirements are concerned for the IEP.
Thank you, Rajeshri. And other questions? No other questions, we'll go ahead and if there is questions, we'll go ahead and answer them. Otherwise, we'll go ahead and
Sonia, I think one of the more common questions that we're getting about the parole program, as opposed from the parole program, is when you get the initial 2.5 years, can you go in and out during that time? As a lot of these entrepreneurs are, they travel quite frequently because they have a nexus to the foreign country. So the answer to that normally is you could travel in and out, but you have to apply for the parole every single time. And it's a quite cumbersome process. And, you want to make sure when you're leaving, you have everything in place. And as of right now, there is no exit and entry once you've been granted the initial 2.5 years. So my recommendation would be, if you paroled in for your startup, plan to stay here for 2.5 years to at least, use up that entire time and grow the business.
Okay, thank you so much, Kirti. And as to IEP, then how much must be invested by India citizen to get visa?
Hi, Sonia. I'll be happy to take that question. So as we discussed a few minutes before, the investment that needs to flow in for a startup in order to qualify for an IEP needs to be from an US-based capital investment or government funding. Unfortunately, if the Indian citizen that the individual here is referring to is the entrepreneur himself, any infusement of funds from the entrepreneur or from a corporation with which the entrepreneur is directly or indirectly involved, unfortunately does not qualify as capital under the IEP.
Okay, and is there any other questions? And what if you want to invest from Canada into an IEP? Anyone wants to?
Sonia, I think I'm not aware of any restrictions or special requirements for Canadians. I believe this IEP program is available to every individual, every nationality, so they would have the same procedure as everybody else.
Maybe we get back to the individual on that one, the question. So from there, I think the question Q&A is over, and see, we'll go ahead and I don't see any other questions. Thank you so much for joining us today. For any further questions or to schedule a consultation, please send us an email at info@chugh.com or email one of our presenters directly using the contact information on the screen. We have live webinars every month and other resources for businesses. Please visit our website at www.chugh.com. That's CHUGH for more resources. We also recommend subscribing to our YouTube channel, Chugh LLP, for great new business content every week. Thank you so much for joining our webinar today. We wish you a safe and happy week ahead. Thank you so much.